Good morning, everyone, and welcome to a new episode of The Future of Europe. I'm Leongrad Christie, your host, and today I'm very delighted to welcome a special guest, Elturan Rustemli, a student at the University Catholique of Lille in the Master of International and European Law. He will share with us its expertise on ill-qual treatment of part-time workers in the EU through the case MK v Lufthansa City Line.
Thank you very much, madam. It's my pleasure to be here.
Let's start with the basics. What was the MK v Lufthansa case about, and why is it significant for EU labor law?
The case of MK against Lufthansa centered on whether a uniform policy for additional flight duties imposed by Lufthansa disproportionately burdened part-time workers, violating the pro rata tempore principle under the Directive 9781 EC, also called Part-Time Work Directive. This principle requires part-time workers to receive employment condition proportionate to their contracted, unless objectively justified. This case is significant because it tests EU's commitment to non-discrimination and proportionality in labor law. The Court of Justice of the European Union had to balance Lufthansa's operational needs against right of part-time workers, setting a precedent for how EU protects atypical workers.
Okay, but can you help us to understand how does the pro rata temporis principle work in practice, and why did Lufthansa's policy conflict with it?
Pro rata temporary principle ensured in Clause 4 of this directive mandates the part-time workers to receive benefits and a working condition proportionate to their hours. For example, a part-time worker who works 50% of the full-time schedule should not face the requirement to work 80% of the full-time schedule. Lufthansa applied uniform threshold for additional flight duties regardless of employment status. This meant that part-time pilots like MK were required to exceed their contracted hours more frequently than full-time pilots. The court found this placed disproportionate burden on part-time pilots, violating this principle.
Okay, as I understood, the CJU ruled against Lufthansa. What were the key legal arguments supporting this decision?
Well, the court's ruling hinged on three key arguments. The first one is violation of proportionality. The uniform threshold was not necessary to achieve Lufthansa's goal, operational goal, let's say. The airline failed to prove that a different threshold for part-time pilots would compromise safety and the necessity. There is second one is indirect discrimination. While the policy in appearance natural, it disproportionately affects part-time workers, constituting indirect discrimination under the directive. And lastly, lack of objective justification. Lufthansa's claim of operational necessity were unsupported by evidence. Court, in the case of CR's Sharjah, emphasized that different treatment must be justified by legitimate aims and implemented through less restrictive means.
Okay, now can you explain to us how this case aligns with broader CJU jurisprudence on part-time workers' rights?
Okay, the ruling builds on long-standing court's principle. In Kut's Bayer case, the court held that pension schemes disadvantage part-time workers for discriminatory and unless it is justified. Elsner case reinforced that the policies must align with proportionality to avoid indirect discrimination. And lastly, in the Blika case, the court established that employer must demonstrate objective necessity for different treatment. The MK and Lufthansa decision reaffirmed that operational convenience cannot override fundamental rights, ensuring that part-time workers are protected under the EU law.
Then, what are the implications of this ruling for EU employers, particularly in industries like aviation?
Well, this ruling sent clear message. Employer must avoid uniform policies that put or penalize part-time workers. Differentiate threshold or adjust requirement may be necessary. Operational claim must be backed by concerned evidence, vague appeals to safety or efficiency will not sufficient enough anymore. Industries like aviation may face higher cost to redesign policies, but court prioritize workers' right over administrative convenience. For example, airlines could adopt pro rata adjustment for part-time pilots, flying hours, or invest in a training to expand workers' flexibility, as seen in Garde des Sceaux case.
Okay, and do you think that this case could influence future EU labor law reforms?
Absolutely. The case highlights gaps in enforcement of the directive, particularly in the sectors with rigid operation demand. Future reforms may strain penalties for non-compliance, clarify the thresholds for objective justification to prevent misuse, encourage sector-specific guidelines to balance safety and workers' rights. As scholar Garben notes that EU must prioritize social inclusion alongside economic efficiency. This ruling is a step toward harmonizing labor standards while respecting operational necessities and realities.
And in summary, what does this case mean for future of part-time workers in the EU?
The court has reaffirmed that equality is non-negotiable, even the high-stake industries. Employer must innovate to align with operational needs with the EU labor standards. For part-time workers, this decision ensures their rights are not sidelined, making a victory for fairness in evolving workplace.
Okay, thank you for giving us valuable insight on this topic, and thank you to everyone for watching into this new episode of The Future of Europe.